last left Chille was busy playing in court, being a nuisance, doing things like filing multiple motions for contempt, instead of filing something to forward his case or actually fix the many flaws found within. Chille preferred to try multiple petty approaches instead of doing actual legal kind of stuff. An example, his emergency motion to dismiss a response to his contempt motion that was 2 days late. He had no other argument, to which the judge responded. Here the court in its discretion will not strike Peter's opposition because it credits the representation by Peter's counsel that the delay was the product of a good faith mistake, and because plaintiff was not prejudiced by this delay, plaintiff's motion to strike is denied. In other words, the judge didn't see any reason to dismiss this. 2 days late was just not long and didn't appear to affect the case. And wasn't there someone else involved on that pro se, plaintiff-y kind of side a few weeks late on one document? They all blur together, so it might have been a different case. Just saying. Of course, Chille could not let it stand and filed motion for reconsideration of plaintiff's motion to strike, which the court promptly replied, denied. So Chille, not being very happy, tried to change the playground and finally filed a very tardy supplemental complaint. The court had been waiting for this one for quite a while, and I would bet this motion was the trigger for today's events. It potentially had the chance to change things and create an actual valid case. In this motion, Chille again repeats the same mistake as the first. He assumed that by adding in even more URLs to the previous list, this was somehow clarifying. And so what he did this time was he sent in a list of 30 URLs linking to various YouTube videos. Some of these URLs were still pointing to people not even involved in the lawsuit. Chille again made no indication of which URL or video Peter or Abrams were actually involved in. He actually made no indication of anything, just a list and a signature. So even if the video was a smoking gun, how would anyone, especially a busy judge, know? Did Chille really expect the judge to watch each of the 30 videos, then decide where and how copyright was infringed and how it had hurt him? Nah. Normally, if you know what you're doing, you might list a URL, explain the infringement occurred at such a time in the video, then explain what the video shows and how that affected you. You really need to show where and explain why, not point at a list and think the judge will do all the work for you. You can't just go, it's over there, judge, somewhere in that 60-hour pile of video. Due to Chille failing to point out any infractions here, Chille had again failed to make any valid copyright claim. Common sense, right? Maybe to you or me. Now, real lawyers, when they show the smoking gun evidence stuff, will make sure they point out the exact evidence. They will be very clear about it, about where it is and how it affects things. After that, they'll make sure to put alarms, bright lights, and fireworks to make sure everyone instantly knows that's the evidence, right there. And it hurt me like this. Chille didn't do any of that, not even using his second kick at it. At this point, a small little company that someone got themselves involved with this, I think they're called Google or something, finally woke up and decided to play with Chille, and promptly filed for a motion to dismiss or to transfer to Northern California court. Google filed a motion on May 23rd to dismiss the case or to move it to a North California court, as per the user's agreement. Everyone has to agree to this and able to use Google or YouTube services. Their motion to dismiss was based on the simple fact that Chille had even failed to register the copyright material, aka Hammer Boy, before filing his suit. Federal copyright rules are very clear in that Chille would have had to have registered the video or tried to register the video with the Copyright Office before serving the defendants. He hadn't. If you haven't seen the Hammer Boy video, it's hilarious. He's tried to delete it or suppress it. So, here it is.
He can't even use a hammer.
Is this an act? Is it?
There has to be a better way.
This is the ultimate alpha male who cannot nail a tree. I don't know. Maybe he's into boy trees. I don't know. Or he just doesn't know how a hammer works. Chille responded to Google's motion by asking for permission to delay his response until 7 days after the court said he could. He was allowed to. I don't know why they did that, but they did. His response was essentially, I are smart, they dumb, they didn't do it right. You can't dismiss. Chille then filed yet another motion for contempt again. Kate, bad woman. Chille's scared. Help, help, help. Finally, July 11th, and that's today, by the way, the judge must have run out of headache pills, happy pills, and patience. Just as a wild guess. The second motion for contempt that he'd filed was Peter did not violate court order, so it was denied. Previously, Chille had decided the bad woman judge had to be doxxed and stopped because she was unfair to him. He does this over streams and videos. And he had tried to dig out the dirty laundry on Judge Burroughs, whom he was now calling sugar tits, on his videos and live streams. So he had filed for disclosure of information, insinuating the judge was unfair to him because she had been given awards or was a friend of the local police departments. And today, the judge said, denied, that it was none of your effing business. The court had acted correctly. Next, the judge issued a decree that the defendant's motion to dismiss and Google's motion to transfer to another court was granted. We're not done yet. Next, the judge granted Castro's motion to dismiss Abrams and Peter's counterclaims. This meant Chille is now not paying Peter or Abrams for damages or costs. Why? Because they used very general terms to describe the damage caused by Chille. They done pulled a Chille. And wait, there's still more. The judge then dismissed the case entirely. All gone, finito, bye-bye. So, after months, the 20-year law scholar didn't accomplish a damn thing. He didn't prove anything, except that he has no clue how a civil suit actually works. Had he made actual claims showing actual damage, then it might have gone somewhere. Instead, all he did was insinuate, and expected someone to jump to a conclusion. Unfortunately, the same can be said on the defendant's side. They did not clearly show how, when, or what the damages were, or how they were done to them. If they had, I'm more than willing to bet Chille would now be on the hook for both legal fees as well as those damages. To be fair, they both had lawyers, and those lawyers failed to do the simple damage claim properly. So, Josh and Kate want to go after their lawyers? That's open. So, that case is now done, finished, finito, you would think. And it should be, to anyone with common sense. So with that said, do you want to bet Chille's going to appeal? It also does nothing to resolve the same exact case Chille has filed in California. So that's still coming up. Now, Chille did not win. He did not even come remotely close to winning. This is a big loss for him. He did more damage to his own reputation than he did to anyone else's involved. He showed just does not know what he's doing. No matter what his claims are, he does not know what he's doing. He failed to prove his case because he failed to do the work, and simply did not know how to. His entire case is based on stamping his little feet and saying, no, like a toddler, every time someone did something. He thought he was so much smarter that he could string along a judge, the court, and real lawyers, and then that would have the effect of draining the defendant's drive money. Personally, I don't think it changed a thing. I still think he's an effing idiot. Now, as a final thought, as the sun sinks over the shore and into the sea in Massachusetts, we can all take comfort in knowing you done stopped, Chille. You done stopped.